you can have other entities actually own property as well. So in Florida now, and actually across the United States, the LLC, limited liability company, is very popular now. It used to be a limited partnership was really popular, but this essentially it's a way to protect the owners of the property from liability spreading to their own personal stuff. So what happens is two, three guys, one person, they start a company and file the correct paperwork in the state of Florida or whatever state they're formed in. So they are creating a legal entity. So this LLC, they can do the same thing with a corporation. They have partnerships. There's ways to create it, but what they are actually doing is creating a new person. They're making a child, and that has legal rights in the state of Florida as well most other states. So uh, Bob and George get together and they create an LLC. They take that LLC. Now that LLC is, and they file the paperwork. Now that LLC is an actual person as far as the state's concerned. That person can own property. So they can take title to Bob and George's LLC, okay? And that is actually the entity that owns the property. It's not the members, it's not Bob and George that own that property, it's the entity itself. They've created a child, and that child is what owns that property. Um, there used to be lots of litigation over partners, and if they had partnerships and they had other forms of ownership, who would actually own the property. Well, that's been resolved over the years with statutes and everything else. Now they actually have the legal right to own the property. So if Bob and George create this LLC, they buy the property with it. Okay, it's going to be in the name of the LLC. The people sign for it. They're the Bob and George are the managers of the LLC. They sign for it, but it's actually the entity that owns it. So that is, it's interesting because you could have two LLCs own property as tenants in common. They each own 50%, or they each own an undivided 2/3% and 2/3 of the property, and then somebody else and a person owns the other third. That can be split up the same way. So you can have a tenants in common with two or three different LLCs, or 50 LLCs could own that property together. Okay, it doesn't work for joint tenants type survivorship though, because corporations, LLCs, and other entities, legally created entities, are intended to survive forever. So you can't have one die, essentially. So that entity would not die. It doesn't work to have it hold joint tenants with rights to survivorship because it doesn't die. Even if the entity does die, say they break up the entity, that still owns the property until it's deeded out of that property of that entity. And usually it's done as rounding up business, closing the company. They end up deeding it, even if it's one surviving member, it's only one left, or one manager that used to manage it. They can deed it out and remove it from title. But again, it doesn't work. You can't really do joint tenants with rights survivorship for entities because those are intended to survive unless they're killed. So um, it's but the LLC's tenants in common can be done. They can own property in common with lots of other LLCs and other corporations and different type individuals. Everything, they can mix it however they want. Um, you also have trusts, and that's the next the trust ownership. Now, trusts are essentially a form of ownership where it's a set of rules that they go by, and ownership of the property is set up by a set of rules. The trust documents themselves determine what the rules are for ownership of the property and where the property goes, who's going to get the money from the property, who's going to get the property if one beneficiary dies. Now, trusts have basically three parts. They have the trust itself that's named. Okay, that usually is, say, it would be George and Martha's survivor estate trust. George and Martha's trust. Okay, that trust was signed on May 15th. okay, of 2020. So George and Martha Trust is further named by under trust document dated May 5th, 2020, because there's a small possibility that there's another George and Martha Trust out there that was created on a different date. When you include the date, you are further limiting possible confusion over who actually owns that property. So it's become statutory really to that it's you name it with the date of the trust that it was created. That way you eliminate possibilities of more, well, as much as possible that something else is going to own the same property. It's like you don't want to have two people with John Smith own a property. Uh, it's named under John Smith. Now you have to deal with which John Smith. So it's the same issue. They use the date included in it. So you have the trust name, and that's the actual name of the trust. But the trust doesn't actually own the property. The trustee owns the property. That is the face for the trust. And the trustee could be a person, it can be a corporation, it can be another LLC, it can actually be another trust. But essentially the trustee is the person is the face in front of the trust who owns the property for that trust. Now they don't have any legal any equitable rights in that property. Okay, they are essentially just running it for the beneficiaries of the trust. Okay, and that's the next part of it is the beneficiaries. Okay. The beneficiaries are who gets who gets the benefit of that property, and that's where beneficiaries came from. Who benefits from that ownership of that property? So you have George and Martha's trust. George and Martha start out; they are the grantors. They put it in the trust. Okay, they take it from George and Martha as husband and wife, and they deed it to George and Martha as trustees for the George and Martha Trust dated May 5th, 2020. Now you have George and Martha no longer own it as husband and wife. They are now own it as trustees, and they have different hats on. Now they're actually a different person acting as a trustee. It's kind of like being an LLC. It's a different entity. So they are no longer George and Martha personally. They're George and Martha as the trustees, and that's a different face on the program. That's a different face on the deed. They're different. They also changes liability issues, and I can go over a little bit of that in a minute. But essentially, they only own that property as trustees for the benefit of the trust, of the beneficiaries of the trust. So if the money comes in, say they rent it out monthly, the money comes to the trustees put it in the trust account, and then they take it out of the trust account and they send it to the trust beneficiaries. The trust beneficiaries could still be George and Martha. They could be George and Martha's children, or it could be a church, or it could be whoever they've designated as the beneficiaries of the trust. Okay, so yeah, what's important is in some states the trust can actually exist without the trustee, and whoever the beneficiaries can actually appoint a trustee. Um, Florida, the trust can exist, but in order to own property, the trustee is supposed to be in the title, or it's supposed to be referred to in another document that can be seen in public records. So when you say, if somebody tries to deed it to the George and Martha Trust and it doesn't say anything else out about the trustee, that creates a problem, and is basically the deed fails because you need to name the trustee. Um, in Colorado, for instance, you can name a trust and just have the trust name and it doesn't fail. This title still transfers. Here you need the name of the trustee to take title. Okay? And those trustees, they're not liable unless they do something criminal, essentially, they're not liable for something that happens on the property. So if somebody slips and falls and gets hurt, if they sue over that, say somebody comes up and falls down on the front walk, they would sue the trustees and the trust, but it's not the trustee that would be personally liable. The trust itself would be liable for the damages. So unless the trustee does something personally to injure somebody, there's no liability for that. Um, that works very similar to LLCs, so that somebody's not personally liable for the actions of the LLC. Um, there's other forms of ownership. There's also estate ownerships. There's You have other things like life estate interests, where somebody can own a fee simple during their life, and then the property goes to someone else when they die. That's a life estate. It can be a life estate can be set up so it's Grandpa George owns the property for his life, and then it goes to the grandchildren. The it's a term ownership. It's basically for a period of time set by, and it could be anybody else's life. It could be, say, Grandpa gets to live in the property and gets a life estate interest as long as Grandma's alive. It could say that he gets a life estate interest as long as the George Washington is president, and then it dies. Cindy, let's see. That's Lady Bird is what I'm getting into next. Okay. The life estate interest is essentially based on a period of time, and then it transfers automatically to another party. So it's similar to a joint tenants rights survivorship, but they don't. It's not a, if they don't own the interest at the same time as 100% interest to the property. So Grandpa George would own the property till he dies, and then it goes automatically goes to the grandkids. That's a regular life estate. Now, in Florida, we have what's called an enhanced life estate deed. That's really important nowadays because it's used to avoid probate. It's used to transfer title when someone dies. But the wonderful part is, during the party's ownership, the life estate tenant's life, they own the property in fee simple. They can sell it, they can mortgage it, they can burn it down, they can do whatever they want during their life. Nobody else has any say in it. The kids don't have any say in it. The people, the survivorships don't have any say in it. The remainderman is who gets the property. They don't have any say in what happens to the property during their life. That's the enhanced part. In a regular life estate interest, if George wants to sell his property that he's living in and has a life estate interest in, he has to get the remainderman's joinder on that deed or that mortgage or whatever he wants to do with the property. Because they, in a regular life estate interest, the remainderman, the person that's going to get the property when they die, they have a vested interest immediately as soon as that deed's created. It's a future interest. In an enhanced life estate interest, that remainderman does not have any vested interest until the life estate tenant dies. So if George will own in a regular life estate, George owns the property, his grandson owns the future interest. And that's immediate with the deed. In the enhanced life estate deed, George owns 100% of the property in fee simple until he dies, and if he still owns that property when he dies, he hasn't sold it, given it away, burned it down, given it to charity, then it will go automatically to the remainderman. All decisions during his life he makes, he doesn't have to have joinder by the remainderman. And essentially, Florida, Texas, a few other states, Michigan, there's not very many states that have that have recognized that, but it's beautiful here because in Florida, because you have to go through probate, if you own the property in fee simple and there's nobody else with survivorship rights to it, they have to do probate. Then you can avoid that with using this enhanced life estate deed. In the meantime, it's not a current gift to the remainderman while they're alive. So if, say, there's creditors problems for that remainderman, that they have no claim in the property whatsoever. So no creditors can get at the property for that remainderman. If when they pass away, when George passes away and the remainderman gets the property, if he still owns it, they get what's called a stepped up basis in the property. And that means the value, if they were to sell it on that date, their basis, how much they actually have into that property, gets stepped up to the value at the time of death. which means if George um, leaves his property to his grandson, um, and George bought it for $10,000, and now it's worth $100,000. If George were to sell that during his life, he's going to have to pay capital gains taxes based on how much he's made on that property. So he would have $90,000 worth of capital gains. If he leaves it to his son or his grandson with his life estate transfer, the enhanced life estate, when the grandson gets it, it's worth 100,000 per basis. So he sells it that same day for 100,000. He has no capital gains to pay. So it's very similar to regular inheritance, like through probate, but you don't have to go through probate. So it's very beneficial for that. That step on basis means a lot for tax purposes. Also, there can be problems adding the kids and grandkids. So we get it a lot here in Florida. Grandparents come and they say, well, I want my kids to get the property, or my grandkids to get the property when I die. I think I'll just put them on as joint tenants with rights of survivorship. Sure, they can do that. But now somebody else owns the property with them, and it may not be their homestead, or it may be that the grandkids have creditors problems. That basically, if George and Martha want to sell their property after they put their grandson on with them, now they got to get their grandson's permission to sell the property. So they're no longer in charge of the property. They have to, and things happen. People get in fights, and sometimes they don't want to cooperate, or sometimes they can't cooperate. So it can create problems. The enhanced life estate deed, this ladybird deed, removes those problems. They still stay in complete charge of the property. Um, Also, it's not a gift. It's not a current gift while they're alive. So there's no worry about gift taxes. Um, there's no worry about giving your property away for Medicaid reasons. It stays their homestead, for instance, and it's going to stay their homestead that way. They don't. Nobody else owns any portion of the property. Um, it also doesn't require payment of doc stamps when you record that deed. And the enhanced life estate deed, if you were due a joint tenant rights survivorship and there's a mortgage on the property, then they would have to pay doc stamp taxes on adding the grandchild to the deed. If they do it with an enhanced life estate deed, since there's no present transfer, it's only a future possible transfer, you don't have to pay doc stamps on that deed. So it can save a lot of money there. So if you have clients that are concerned about the property transfer if they pass away, it really is important that they look at this as a possibility, because it leaves them in complete control of the property, and they still get the benefits of the future ownership to the grandkids. Um, those are the majority of what we deal with on a regular basis. There's other types of um, there's estate deeds. There's other types of ownership by essentially, say George dies and he's in probate, his estate owns that property. So you could have a deed from the personal representative from the estate. Personal representative is the person appointed to take care of a deceased property in the court by the court. So you could see things like personal representatives deeds. You could see things like executors deeds from other states. You could see um, there's deeds from a bankruptcy estate, when you have a trustee for the bankruptcy could take over the property and end up getting a deed. But essentially, in one form or another, they are one of these issues. They're either single ownership, they're tenants in common, they're joint tenants with rights to survivorship, they're tenants by the entireties, or they're one of these other entity estates, like a life estate.